the primary level, at the high school level, at the graduation level, even at the time of recruitment of the personnel. So this is one area that is the biggest challenge that is faced today. What are the basic philosophy behind for incorporation of the syllabi in the learning process? Now the National Council of Educational Research has conducted a research and they have incorporated certain elements of human rights in the component of civics, in the component of social science, in the component of learning the language also. No, it is not a formal education. Formal education of human rights is not the concern today. Informal education of human rights is the present day scenario that needs to be addressed, and it has to be addressed in a very effective way. My only suggestions for the teachers to formulate a curricula for the students to develop a sort of inculcation in the mind of the young boys and girls, the need for human rights, it should be in the form of role models. So there is need, it should be a practical oriented approach is to be considered one of the essential requirements for human rights education in India today. So how to bring up a sort of caliber among the young students to know about the need for a human rights education in the schools. You pick up some students, you give them some particular topic. I will just give an example of the problem of untouchability. How the problem of untouchability could be made known to the younger generation to see that Constitution provides for equality, social equality. Untouchability is to be prohibited under the provisions of the law. Under Article 17 of the Constitution, totally prohibits the concept of untouchability. In different form, in pursuance of that also, Indian government has enacted a law that is practice of untouchability in different form is prohibited under the law. How to build this particular structure among the young friends? That is to be only through the practical approach. The students have to be oriented. Now we can take the example of Dr. Ambedkar's plight. He was the first sufferer for human right because though equality of opportunity was given to him, how Dr. Ambedkar was treated when he studied in the school, what kind of treatment was given to him. So if such part of instruction is given to the students at the beginning of the learning process, and the student will be able to know what the concept of equality, what Dr. Ambedkar realized, how the concept of equality is realizable under the perception of the Constitution. That can be done through a role model. That is, role play can be, or that a particular scripture may be produced, and different roles to be given to different students to enact a drama, so that it is more impressive and it can remain in the minds of the younger generation as a part of process of education of human right. Coming to another important aspect, now I was just taking a reference to the violation of human rights by enforcers, so-called police department. In case of police custodial death, how the concept of violation of human rights are perpetrated directly by the state. So that is a need to inculcate this feeling also among the younger generation to give them different roles to play, and how different authorities under the law are virtually violating the basic human rights of the individual in a society. So that is also to be trained up through not through the formal education, it can be done only through informal education. That in that way, we can see that maybe we can think of formulating a very effective model curricula for teaching human rights in different stages of education. This is a formal teaching of human rights education. Informal teaching of human rights education has a more impact on the minds of the students. That is the one suggestion which I am going to make in my paper. I have made a detailed study of different stages of human rights education in India and what are the areas in which it is going to be covered. Maybe environment, right to safe drinking water is one of the fundamental right of every individual. It is a basic human right. How safe is drinking water today? Whether the individual can really fight for the enjoyment of the right to life, which is inclusive of right to have a safe drinking water. If that is not realizable, what is the duty that is cast on the part of the state to provide a meaningful life to an individual It is not merely an existence of animal life. The individual should be ensured with a dignified life, that is meaningful life. Meaningful life can be realized only when the recognition of the human right concept is provided through the different stages of education. Now, in my conclusion, I would say that lack of funds or paucity of funds should not be a problem for the state to inculcate human rights education in different stages of level. There is a dissemination of information pertaining to human rights that is the need of the hour, and the ultimate slogan during 1995 to 2004, the UN declared the era of human rights education. Now, all human rights for all, that is the ultimate goal for which Universal Declaration of Human Rights Convention was, international instrument was developed, and on the basis of this instrument, most of the constitutional systems have adopted the concept of human rights at the time of making the decision as a part of Article 21 of the Constitution. And Indian Supreme Court has done a commendable job in recognizing different phases of human rights concept in the forum of judgment that is passed, just to see that the human rights are ensured to every individual without any compromise. With few words, I would extend my thanks for the organizers for giving me an opportunity to say few words about the need for human rights curricula in education. Thank you all.
So he has highlighted the various levels of human rights education in India, and he has stressed the need for informal type of human rights education in India, and it should be creating an awareness in the young minds. And he has encouraged us all who are present here to formulate a model curricula in this manner. So, and I am very thankful to him for keeping that time. Now, may I have the pleasure of inviting Mr. Manu Sharma to present his views on prisoners' rights.
Good afternoon, everybody. I would like to move on to the topic straightly. Prisoners retain their basic rights despite the imprisonment. Prisoners lose only those rights, civil rights especially, which are directly taken away by an act of the parliament or by necessary implication. For example, prisoners do not have the right to vote. The Representation of People Act clearly prevents the prisoner from franchising, except those who are detained under preventive detention law. The citizens who are detained in prison, may be convicts or under trials, are entitled to the benefit of Article 21 of the Constitution, that is, right to life and personal liberty, subject to the reasonable restrictions. Now, handcuffing of prisoners. Prisoners cannot be handcuffed unless there is express authorization from the concerned magistrate. I would like to quote Prem Shankar Shukla versus Delhi administration in this regard. It was held by the Honorable Supreme Court that handcuffs can be used by the escorting police authority if the prisoner is dangerous or desperate, or he is likely to break out the custody, or if he is playing some vanishing tricks. Further, it was held in Sunil Gupta versus State of Madhya Pradesh that escorting police authority should record the reasons in writing for handcuffing the prisoners, and same has to be intimated to the court of law so that the court can consider the necessary circumstances, and also it is possible for the court to issue necessary directions to the escorting police party. In Sunil Batra versus Delhi administration, it was held that handcuffs shouldn't be used in daily routine manner. Even the prisoners are entitled to the benefit of Article 19, that is, right to freedom of movement. In state of Maharashtra versus Ravikant S. Patil, it was held that handcuffing under trial prisoners is violative of Article 21 of the Constitution. In Prem Shankar Shukla versus Delhi administration, the Supreme Court of India laid down certain guidelines when handcuffing the prisoner. When handcuffing the prisoner, the escorting police party must form their opinion as to he is a dangerous criminal on the basis of the antecedents of that particular person. A prisoner cannot be handcuffed merely because he has been charged with grave offense. Prisoner cannot even be handcuffed just for the convenience of the escorting police party. Supreme Court in the same case has also laid down certain alternative measures instead of handcuffing. First one is increase in the number of escorts. Arm the escort sufficiently if necessary. Give special training to the escorting party. Transport the prisoners in a protected vehicle. So, by adopting the alternative measures laid down by the Supreme Court of India, handcuffing is virtually abolished in the state of Tamil Nadu. One more important thing is, any violation of the directions issued by the Supreme Court of India in Prem Shukla's case would attract the provisions of Contempt of Court Act. So, existing system, it gives absolute discretion, absolute and unchecked discretion for the police authorities. By making use of this unquestionable and unchecked discretion, they can place anyone and everyone as dangerous elements. They can label everybody as dangerous elements. So, it is not difficult for the police to say that just to prevent the prisoner from escaping, we have handcuffed him. So that there is every possibility that police justify handcuffing even innocent persons. But as per the guidelines of the Supreme Court, prisoner may escape. This is not the reasonable ground to handcuff the prisoner, because it is the responsibility of the police authorities when escorting him to see to it that he is not escaped. But Supreme Court has laid down certain alternative measures also in this regard, so that handcuffs can be avoided. Therefore, I strongly feel that a new law shall be brought into force, under which this handcuffing shall be completely banned. When purpose of handcuffing can be better served by adopting some alternative measures directed by the Supreme Court, there is no need of continuing with existing handcuffing provisions. Present law permits handcuffing only under exceptional circumstances, but I feel these exceptional circumstances can be better tackled or handled by alternative measures suggested by the Supreme Court. Escorting police party under the existing system is permitted to handcuff the individual if he forms the opinion that he is a dangerous element, so that he is producing the prisoner in front of the court. Usually, court refuses the permission to handcuff the individual because there are certain alternative measures. But from the time of his arrest till he is produced before the magistrate, his right to life under Article 21, which also includes right to human dignity is curtailed. In my opinion, not even 1 minute or 1 second, the right to human dignity can be curtailed without proper procedure established by law. So, existing provision on handcuffing will not serve the best purpose of Article 21, and it gives scope for the abuse of discretion on the part of police authorities. So next right is right to meet friends and family members. In Francis Mullin versus the Administrator, Union Territory, Delhi and others, the court held that personal liberty under Article 21 include prisoners' right to socialize with family members. In another case, Ramamurthy versus State of Karnataka, a prison rule which permitted only one visit in a month was held to be violative of Article 21 of the Constitution. And prisoners also have the right to read and write the letters. So, writing a book and getting it published, it is covered under Article 21 of the Indian Constitution. Any violation without the authority of law would amount to the violation of right to life. Even prisoners can write the letters to the other prisoners. According to Rule 17 of Maharashtra Prison Rules, it permitted the prisoner to write a letter to the prisoner who is also his relative, but he is in other jail. But he is not allowed to write a letter to his friends who are in other jails or outside the jail. So, this particular provision was held to be violative of Article 14 of the Constitution, that is right to equality. Supreme Court in the recent judgments has also stated that ban on letter writing right of the prisoner would amount to the violation of Article 21, that is right to life of the human beings. With this, I would like to conclude my presentation. Thank you, Anand.
And with respect to handcuffing, Mr. Manu Sharma has said alternative measures should be taken. Recently in Tamil Nadu and other things, we are dealing with dangerous criminals. Video conferencing and using the video, recording the evidence through video conferencing is permissible. So we can also think about the using technology, so keeping them in the cell and I am surprised that he is a student and he has presented his paper very well. He is a final year LLB student of this college and I am very proud to chair the session when he is presenting the paper. And the same trend will be followed by the next speaker also, I believe, and I hope sincerely. Ms. Veena also will be presenting her views on prisoners' right. She is also the final year LLB student of this great institution.
Good afternoon, everybody. I would like to straight away move on to the topic. Custodial death, the worst kind of crime in a civilized society. The death in police custody is one of the worst kind of crimes governed by the rule of law and possesses a serious threat to an orderly civilized society. Torture in custody flouts the basic rights of the citizen and is an affront to human dignity. The importance of the affirmed rights of every human being needs no emphasis, and therefore it becomes a sacred duty of the court to deter its breach. Custodial violence, including torture and death in lockups, strikes a blow at the rule of law, which demands that the powers of the executive should not only be derived from law, but also should be limited by law. Custodial violence is aggravated by the fact that it is committed by persons who are supposed to be the protectors of citizens. It is committed under the shield of uniform and authority within the four walls of a prison or lockup, the victim being totally helpless. Personal liberty is fundamental to the functioning of our democracy. The state has to control and curb the malefied propensities of those who threaten the life and liberty of others. The purpose of Article 21 of the Constitution would be defeated if the state does not take adequate measures for securing compliance with the same. It is for the state to ensure that the persons live, behave like, and are treated as human beings. It is an obligation of the state to ensure that there is no infringement of the indefeasible rights of a citizen to life except in accordance with the procedure established by law. While the citizen is in its custody, whether he be a suspect, under trial, or convict. The wrongdoer is accountable and the state is responsible if the persons in the custody of the police is deprived of his right to life except according to the procedure established by law. Death in police custody entitled for monetary compensation under Article 32 and 226 of the Constitution of India. The grant of relief to the heirs of a victim of custodial death by invading his rights guaranteed under Article 21 of the Constitution of India is not always enough to relegate him to the ordinary remedy of a civil suit to claim damages for the tortious act of the state, as that remedy in private law indeed is available to the aggrieved party. Compensation can be granted under the public law by the Supreme Court and the High Court in addition to the private law remedy for tortious action and punishment to wrongdoers under criminal law for established breach of fundamental rights. I would like to draw reference to a case law, that is Nilabati Behra versus State of Orissa, where the Supreme Court, while ordering compensation of rupees 1.5 lakh by the state to the petitioner for custodial death of her son, aged 22 years, reiterated the compensation for contravention of human rights and fundamental freedoms as guaranteed in the Constitution is an acknowledged remedy for enforcement and protection of such rights. Similarly, reference can also be made to the case law Aravind Singh Bhaga versus State of UP, where they have made it crystal clear that the erring police officials should also be prosecuted along with the compensation that is being paid. The award of compensation in the public law administration is without prejudice to any